the Second Circuit says it, very important if you're in the Second Circuit to this specific New York statute. But when the BIA says it, it's nationwide,
Hmm.
right? And it could apply to other statutes. And now when the BIA says it, as it must, you can use that logic to apply
Interesting.
it to other state statutes. I mean, that's just how it works. And what's happening here is the Second Circuit, before the BIA, well, the BIA analyzed it precedentially, I believe. Maybe in matter of J.M. Acosta, the BIA analyzed it precedentially, and then the Second Circuit came in. It's New York Criminal Penal Law, Section 460.30. And that law, as I understand it, essentially is a late filed criminal appeal in New York. I mean, usually based on, most states in most contexts, you have like 30 days to appeal. Usually. I mean, there's a
Hmm.
million statutes. But this specific New York statute allows for a late filed appeal after, I want to say, a year and a month.
Uh,
And it's a late filed appeal. And the BIA was saying, well, no, I mean, you file a late filed appeal, whatever. The appeals court can accept that appeal, they cannot, but that's not a direct filed appeal. You can still initiate removal proceedings based on a criminal conviction, even if this 460.30 appeal is filed. And the Second Circuit came in and said no. And at least with an accepted late filed appeal, but I'm not even sure that's the holding. With this late filed appeal, a criminal conviction in New York is not final,
hmm.
which, from a practical standpoint, I think means because they can be filed, I think, a year and a month, it would appear that DHS can't initiate removal proceedings based on a New York conviction until it's been like a year and 31 days. I mean, it's pretty wild. And this is some of the rationale that the
Yeah.
board and ICE was arguing. The Second Circuit came in and said, no, this happens as a matter of course. In New York, we're treating this like a direct appeal. And obviously, if successful, the person doesn't have the conviction, but it's not final because we're treating this as a direct appeal. That's a big deal, for especially for LPRs with criminal convictions and all the things that can happen when you have a year to challenge this on appeal, and maybe you're collaterally doing things at the district court, at the
Yeah.
trial court level. Who knows? But a big deal, matter of Brathwait. And as I said on the podcast, then what other state criminal appellate law statutes are similar to New York Criminal Penal Law Section 460.30? I mean, you got 50 states. What are the other 49 late filed appeal statutes like? And if they're similar to this, to me, the logic of matter of Brathwaite
Yeah.
would apply, and we should be considering those late filed appeals as making convictions non-final as well.